In with our first session for the day of Fireside Chat. All rights reserved. And to take us through this, may I have the pleasure of requesting Anil Lale, General Counsel, Viacom 18, and Lohita Sujit, Senior Director, Copyright and Digital Economy, Motion Picture Association, to take stage, please.
I think it's great that the program today is starting with this discussion because I don't think any creator, especially when you work in the advertising industry, you're selling a brand and everything is driven by intellectual property. And I don't think the ad industry especially understands the value of intellectual property. And I'm really happy to be chatting with you, Anil, today. Could you take us through what aspects of IP the ad industry really needs to know and, how does it really benefit their clients?
Thank you, Lohita. So, when we talk about IP, most of you will know that IP will include copyright, trademarks. These are the two laws, at least, which is specific to content creators. When I'm talking about content creators, it is not just ad creators, but it also extends to filmmakers, broadcasters, everyone. So, what is copyright? Copyright is an economic right which is basically guaranteed to the creator, the author, or the owner of a particular work which is recognized under the Copyright Act. So when you create such work, the work can be a literary work, which can be a script written for an ad, or a script written for a movie, or it can be lyrics that is written for a song, or a musical composition. There are certain categories of work which are recognized under the Copyright Act. So when you create it, you get that economic right to commercially exploit it for a certain period of time. So that is the, that is the most important right which actually encourages further creation. If that is not there, then there is no benefit in creating any work for any of the authors out there. If you look at any content creator, what you should look at and what you should be careful about when you're dealing with Copyright Act, in my view, first of all, I have often come to, there is a question that comes to me most of the time, or there is a complaint that comes to me most of the time that my idea has been stolen. So what happens when you have an idea and how can you protect it? Unfortunately, under Copyright Act, you cannot protect an idea. An idea per se is not copyrightable. There is no protection that is there to an idea. To understand this better, you have to also understand that what's an idea. Idea means, let's say, let me just put out an idea for you. There is a hero, there is a heroine. The hero meets the heroine. There is a villain that enters, and there is an issue that happens. And then the hero basically fights with the villain and rescues the heroine and rides off into the sunset. This basically forms part of the idea of 90% of the movies, at least made in Bollywood, right? But if this was protectable, then that 90% of the movies would never have been made. So what is protectable under copyright is the expression of the idea. So every movie with the same idea, how it is expressed, that is what gives you a copyright protection. So if you have an idea which you believe is unique, especially for the ad industry, this becomes more important because ideas are more important for them. And between expression and idea, the distance is very less compared to what you will see in a movie which is a long-form content. So if you have an idea, till the time you have been able to flesh it out into a proper expression, keep it to yourself. Because once the idea is out, let's say there is a movie which is out, with the same kind of idea or the same kind of theme, if the expression is different, it is absolutely not an infringement. That is a protection under Copyright Act that the other person will have. So that is one part of it, idea. Secondly, when you are creating content, if you are using any kind of third-party material in the content, I've seen this in marketing materials that we also put out and all, people have come and said that, look, I'm just using a background image, and the creative in front would be completely different. So isn't it fine? I mean, doesn't it come under fair usage? So fair usage is a very, very dear theme for a lot of marketing teams and ad makers, even for when we create movies and all those things. But what we need to be careful about is that whether it's an image, whether it's just one line of the song, that has a copyright in it. So if you are going to use any of this, this has to come with licenses. And what is fair usage? Because this conversation segues into the theme of fair usage. What is fair usage also is something that we need to clearly understand. There is one section called Section 52 of the Copyright Act, which says that what does not amount to infringement of copyright. As in, when you use a copyrighted work without the license, without the permission of the owner, it still doesn't fall under infringement. There are specific scenarios which are set out under Section 52. And only under those scenarios, like news reporting is one of them, criticism, review, all these things, there are a lot of these kind of scenarios which are set out under Section 52. These are the only scenarios which will actually protect you under fair usage. Without this, if you are using any element of a third-party work in any work which is going to be commercially exploited or otherwise, it can be deemed to be an infringement.
Could you highlight certain points, because it's the advertising industry, I truly believe they really, create IPs for a brand. If you look at the Limca Girl, or you look at the Ben in Blue, taglines, right? You recognize a product because of that. So what are the elements of IP there, and what should they know? Can you protect a tagline?
Yeah, that's a very interesting question because, now, earlier, we all would be very, conversant with trademarks. Basically, there is a brand, let's say, let me take the example of Netflix here. So Netflix, you see Netflix as a brand, the word Netflix. It's written in red, it's written in a particular kind of font. All these are protectable elements as far as the brand is concerned. So let's say Netflix has a tagline, some kind of tagline written along with it. So that tagline also becomes part of the trademark and it also gets the same element of protection. The more you use the trademark, the more the trademark is protected. When there is an infringement, when it's protected, the more you get, the trademark gets the protection from law as well. But
Yes,
apart from...
Netflix definitely has a sound mark. I don't know whether
Yeah,
that's protected,
exactly.
the Tadam, right?
So,
but what can the ad agency do, when they create this, and how does it really benefit both the ad agency and the brand?
yeah, so when an ad agency is creating any kind of, let's say brand ident, as we call it, it will come with a trademark, it will come with a logo of the brand and the tagline. Those things are basically protected by the brand itself because that is very important for them to start the business itself. Then comes the sound mark, which you refer to, is where a musical composition is created. And if it becomes part of your identity, you need to ensure that the ownership of that particular musical content, musical composition that is written. Even Tadam is a musical composition. So it has to be secured properly and you need to ensure that all the rights in that vest with the brand. So as an ad maker, you will need to have those discussions with the brand if the brand itself is not having the discussion, but mostly the brand itself will have discussions with you because if you are creating a brand ident, it becomes very important for you to secure that. Otherwise, you publish it once and it becomes important and integral part of the brand, but you don't have the ownership of that particular musical content, which becomes your sound mark, like trademark. Now the new thing is the sound mark. Then the protection of that whole thing becomes kind of suspect.
Moving on, do you see any challenges? So we are talking about infringement, when you look at piracy in content. I don't know if people know this, but the Indian media and entertainment industry lost $2.8 billion, largely driven by the pandemic. Obviously, people were watching a lot of content, and it's kind of ironic. While we say that digital content really had an upstart, the piracy also increased. So what are the challenges that you see there?
Yeah. So the unfortunate byproduct of the content creator economy is piracy. So without any investment, without sweat of brow, putting any effort, they just rip off content from the OTT platforms and the broadcasters, as in the channels which broadcast content, and they just put it up on their websites and services and apps. And it's given free of cost, at least that's what the people who go to those websites think, or apps think, that is free. But as all of us know, there is no free lunch. So what happens here is that when you go to those apps, your personal data is mined. That personal data can be used for a lot of nefarious purposes. And apart from this, there is this huge ad network also, which is kind of synced into these pirate websites, which basically feeds these pirate websites. And the revenue that is earned from those pirate websites also can be used for a lot of nefarious activities, including maybe funding terrorism kind of things as well. So what we need to understand is that, piracy itself is not just one crime. It's a buffet of crimes. And whenever we watch this kind of content on pirate websites, you are not only, creating a lot of issues for lot of the artists and the content creators who work in this economy, and because that's the money that's actually due to all of these people, but going to these pirates, and it's becoming a parallel economy. So that is a big issue, and from a legal perspective, if you look at it, we have Copyright Act, we have infringements which are coming under Copyright Act. But all those things are good to handle, someone using a particular composition or something without license, or maybe running one of the movies as one-off in one of the platforms or something like that. But what we all as an ecosystem, including the lawmakers, need to understand is that piracy is not just infringement, it is a business of infringement, where, the apps and the website which basically puts out pirated content is predominantly peddling infringed content. It's not just one content. So the law also will have to look at it from a very different lens to kind of control this menace.
So, from an advertising agency point of view, I truly believe that as an advertising agency or a communication agency, and therefore, in a way, you also protect the brand, right? You protect the reputation of the brand. And it's unfortunate, when you look at piracy, a lot of ads of well-known brands come onto pirate websites.
True.
And that's because your advertising engines are automated, right? How do you see, and I know that, Viacom 18, you all do a lot of work. So could you take us through what are the various ways in which you can protect? Because I think the agencies play a great role. They decide how, your CPMs, everything is calculated through a media and ad agency. What are the efforts that you all do?
So more than, I would like to actually address this from an industry perspective. If you want to actually fight piracy from the perspective of cutting their revenues, I like to call it demonetizing piracy, is something that we need to, as an industry, we can actually strive for. As ad makers, as brands, if we take a pledge that we are not going to advertise on pirate websites and communicate that to the ad aggregation networks, saying that it is not okay to have our brands, our advertisements on pirate websites and services, that actually will help in demonetizing piracy to a great extent. And that will go a long way in fighting this menace, because without a revenue model, even a pirate cannot survive, because they also have costs for putting up the content, running the servers and all those things. So demonetizing piracy will go to a great extent. And on that note, Lohit, I also know that you work with a lot of content creators and all. What do you think, how can the industry come together to fight piracy as an ecosystem?
So, when you look at content infringement, unfortunately, people don't see it as a pipeline. So everybody treats it as services required to create a brand, but in my opinion, it's an entire pipeline and an ecosystem. So I know of countries in the US and various parts of the world, content creators become one. So I think advertising agencies are also content creators. This industry also tells stories, so they come together and then there's a concentrated effort. For example, if I have a media agency that works on a particular brand, you obviously allocate certain advertising budgets, and then you have a back channel to understand where those ads have appeared. You can actually ask that. And when you know that those ads have appeared in pirate websites, then you get together with studios like us, and you have a concentrated effort in creating reports which goes to the government and to choke the revenues. But it really needs to start with the ad industry, because they are the gatekeepers, right? If you say, this is the list, you send it to the brand will obviously approve that list, because you don't want your brand, the advertisement to appear on a rogue site. But it really takes a lot of effort, and I think the Advertising Association should make this their #1 priority, because it will save brands. Like even Viacom 18 will benefit from that effort. All you need to do is get a list, ask for accountability. I don't want to name brands, but most of the, the AdSense, for example, is owned by a big intermediary, but they're not accountable. But the ad industry can actually be the gatekeeper to that.
That's true. That's quite important. As in, the major problem that when we fight piracy legally, also what we find is that we as lawyers or the legal system here have jurisdictional boundaries by state, by nation, and everything. But the pirates who is operating in the global World Wide Web. They don't have any jurisdictional limits. They sit outside somewhere where we just cannot reach them. And even if we are trying to reach them, even if we are able to identify them, the problem that happens is the prohibitive cost for an IP owner to take such action. And because of the prohibitive cost, some of the content owners shy away from taking such action. So if there is some kind of, also from a legal perspective, if you look at it, some kind of a nodal agency of the government with public-private partnerships, like,
Yes.
you also know that we have a public-private partnership at a state level right now, which is called MIPCU, which is Maharashtra Intellectual Property Crime Unit of the Cyber Cell of Maharashtra Police, which is actually a public-private partnership where we, some of us together are providing the technological support to the police and help them in investigation and identifying these pirates. And action is taken. And some of the pirates who reside within India, we have been able to bring them to justice. And a lot of websites have been blocked and all as well. But again, coming back to the issue is that I think also a consolidated effort from the industry and the gatekeepers where the revenue models can be choked is quite important, as you said,
Yes.
Lohita.
Tell us a little bit more about, Metaverse. We're all converging. I also see that there's a lot of content sponsorship today. But how is it all going to translate in the Metaverse, especially for the advertising industry? What should they really keep in mind? I thought your input on sound marks was amazing. I don't know how many sound marks the Indian ad industry even creates, but Metaverse could change all of that. So what are the key aspects that you could highlight?
Yeah, so Metaverse, it's become a catchword for all of us right now, and it's more of a marketing tool right now to have, we have bought land in Metaverse, we have started a business in Metaverse and all those things. We read in newspapers on a day-to-day basis. But the fact remains that Metaverse is still a very distant dream. The actual Metaverse as it is envisaged. If you look at Meta, Microsoft, all of them are working on different metaverses. Now, that is one thing I'm still trying to struggle to understand. If you have different metaverses, that means, at the end of the day, metaverse it has to be a replica of the world that we live in. So you buy land in metaverse owned by someone. So that means, okay, I have, let's say, land in Colaba. And the same land in Colaba would be available with Facebook and Microsoft. So does that mean there are two lands in Colaba? So there is a lot of things that needs to be worked upon. First of all, to support Metaverse, there is something called Web 3.0, which is a decentralized web. We are still on Web 2.0, which is not decentralized, which are server-based. So that has to come up, first of all. And secondly, on this Web 3.0, the metaverse has to be built. There has to be interoperability between the metaverses for a uniform metaverse to be established. So all these things are, this is a super vision to have, that a parallel universe can be built on digital medium, on the World Wide Web. But to achieve that, the technology also has to support it. Like now we have virtual reality goggles. But that only gives you virtual reality or augmented reality. Apart from that, Internet of Things, virtual reality, and blockchain, all of this has to come together to form that kind of this thing, and it also has to look realistic. Now we would have seen, Mark Zuckerberg also putting his pictures up of his avatars. It doesn't look real. I mean, unless and until it gives the realistic feel to you, the metaverse will never, take off in the way that it is being envisaged. And what challenges that it may face also is because metaverse also uses heavy usage of AI, artificial intelligence, and a lot of works will have to be created by artificial intelligence. It's not possible for human beings to sit and create each part of the universe. There will be a lot of things that will be created by AI. Now, when you look at the legal challenges of creation by AI, is that there is no uniform law. As in, copyright is almost uniform across the world because of the treaties or the World Intellectual Property Organization, where municipal laws, as in the state, every nation's law has to align with the WIPO's, the treaties that has come out from WIPO. So, but on artificial intelligence, or creations of artificial intelligence, every country has a different take. For example, if you look at US, it's very clear that only a human creation will get copyright. Whereas in UK, anything created by a computer, the person who is causing that computer to create it will be considered as the author. So there is a copyright protection. And India also following whatever laws that the UK laws, in 1957, we also have a law which can be interpreted to give kind of copyright protection to AI-created works. But unless and until uniformity on all these things comes, the AI-created works also will face a huge challenge. That also is going to be a huge challenge for the evolution of Metaverse, is what I feel.
So to conclude, could what are your views on how agencies can actually incorporate the value of IP? To give you an example today, if you look at a brand like Disney, or you look at a brand like Spider-Man, you constantly invest in the brand. Spider-Man has gone from being, he's really young now to appeal to an audience. Merchandise sales are really going up. And somewhere I think agencies create properties every day. Probably they don't realize it. So what are your views and how can they really inculcate the culture of IP within, while they're also protecting brands and communicating about them, right?
So, protection of, it is like a kind of a chicken and egg situation there, as in, when you create something, sometimes, yes, it is created with the vision of making it a franchise and making it something that can create sequels, prequels, and all of those. The whole universe can be created around it. Sometimes it is created just for one particular program and then it becomes a runaway hit, and then organically it becomes a franchise in its own. But what I would suggest is that whenever you create an IP, always have the vision of how that IP can unfold, what the potential of the IP can be, and approach it in that manner instead of doing it on a piecemeal basis and say that, okay, this is just this IP, let us get it out, let us just, deliver this. So every IP needs to be supported with a vision, and that vision should also include a what you call legal strategy to how to protect it and how to also include the franchisee models and all those things as well built into it. So
both of us come from the content and storytelling industry, so I think we can leave this thought with the industry here. I have never seen a mascot for a product tell a story on video, and we do that all the time in our business. So let's think about that, and we're open to questions.
yeah, thank you. Sure.
Hi, very good afternoon to you, and thank you very much for this very enlightening talk on copyright. I want to focus on a thing that you had mentioned. This question is for Anil. And you had talked about musical compositions, which is an area which is a very gray area and has been for as long as there have been musical compositions. Now, as you well know, if you can tell us, when you say you copyright a song, do you have the notations of the musical content, which is the melody? Or do you copyright the lyrics? Or do you copyright both? Because if you copyright the lyrics, that's understandable. But when you come to the melody side of it, would you then require the melody to be sort of written down in the musical notations for you to be able to say that these musical notations have been violated in terms of copyright?
So that's an excellent question. And so under Copyright Act, musical composition itself is defined as a particular work, as in which gets copyright. And how you get copyright is when you publish a work. There are two ways to get copyright. One, you can register the copyright with the copyright board, or you can go and publish it by virtue of publishing it. When I say publishing, it's communication to public. The moment it's communicated to public, like broadcast or even live performance, wherever it is, then the copyright starts from that day. So if you look at the musical composition, which, yes, obviously it would be a notation kind of thing, if it is written down and if it is presented to the copyright board for registration, then you get copyright, you can claim copyright from that day onwards. Or if it is made part of a, let's say, a song that is created, any song in a movie, so what all will that song have? there are different copyrights which are encompassed in that song. One is the musical composition. The musical composition is performed by the musicians. The lyrics are performed by the singer, and the whole thing is recorded, or the music director basically directs the whole thing, and the recording is done by the producer, and the sound recording itself also becomes a separate work. So once the sound recording is communicated to the public, the copyright comes into existence for that sound recording, for the lyrics, as well as the composition. So from that day onwards, the copyright protection will be available for all three.
Well, that only answers part of the question. My question to you actually was that, yes, I understand that everything is copyrighted, but in a melody, what is it that you can copyright? Is it the notation of the music?
Yes.
You see, in a musical composition, I can sing the song to you, I can record the song for you, but if you change a single note in the melody,
Yes.
the entire composition then changes.
Can change.
Technically, you could say that I did not change this melody, although you can have the entire melody, but in one place, if you, from G major, you play it in F major, I mean, the entire composition, I mean, how do you copyright actual music? Is it notations that you copyright? Is it necessary for a composer to send to you, as a legal person, the notations of the music, or can I just send you a recording of the composition?
So to answer that, when you look at musical compositions as defined under the Copyright Act, it is the notation. Absolutely, it's the notation. However, that notation, when it is that notation itself is what is performed. So let me give you an analogy to a speech, right? The speech is written down, and that written down speech is a literary work. The moment I give that speech to you, then it becomes a performance of that speech. So when I perform that speech to you also, the copyright exists in my performance, that's the performer's rights, and also the speech that I perform to you, the literary work. So there are two ways. One is direct, notation is a direct, speech is a direct. That copyright gets assigned the moment you publish it. You may also publish the notations on a website. Let's say you don't make a sound recording at all. You don't perform it at all. You decide to publish it on your website, the notations. You get copyright in the notations. You get copyright in the composition itself.
Yeah, because performance rights is something completely separate. I mean, I might have a story, I might then get it
Absolutely.
registered with the Story Writers Association.
Absolutely.
It may never see the light of day.
Correct.
But the point is that I understand in lyrics, you see, there's the nuance there, Anil.
Yeah.
As far as the spoken word is concerned and lyrics are concerned and dialogue is concerned, you have actual dialogue, and the language of that is that you write it down.
Right.
Now, the language of music is there's a little gray area here.
Correct.
Because I can play you a composition and say, look, this is my composition. But if somebody is going to pirate that, they will turn around and say that is not your composition because we have changed one notation.
Yes. So this, you're absolutely right on this. So when someone changes one part of it and says that it is a completely different music, then it will have to go to someone who will have to compare both of this and see whether this is the same thing or not. And that is how you see, like, most of the matters before court is on those lines itself. As in, there is even a thumb. It's not the whole song. Even one small part of that music, one thumb, also has been part of litigations in the past.
Yeah, which was my question to you, that you as a legal person, I bring a song to you and I tell you, please copyright my melody.
Yes.
Will you ask me to put it down on notations, or will you say just the recording is enough?
If I would, it's both, but if you have not made the sound recording yet and it's not published yet, then, and still you want some kind of copyright in it, I would say bring the notation, let us put it before the copyright board, and let's get a
To
registration.
make it
Fair
a
enough.
little bit more simple, there's a 3-step test, and ultimately it also goes to the audience. So if an audience can say, "Aapne dhun badla," what you're talking about is dhun, right? I changed the dhun to a certain extent. But the audience still can recollect the original song. It's copyright infringement. So courts are very fair. So it's not
Audience,
just legal.
I don't think the audience, I'm sorry, but I don't think the audience has got anything to do with this. This is a composition.
No. So when you do
The
the
audience
test,
can perceive it. See, the audience generally, if you change, believe me, in a notation, in a musical composition, if you put the musical score down and you change one semitone here and there, it's very difficult for the audience to pick it up. Technically, a musician will pick it up and say that you have changed a notation, rest of it is all there. To escape copyright is what my point is. My point basically was, what is the legal parameters to actually copyright a melody, was my question.
So melody, what I just explained earlier is the thing. If it is there as a sound recording, you get copyright. But if it has not been made into a sound recording, then you can actually go to the copyright board and register your work as well.
Fair enough.
And if in the future it gets infringed, you can actually go with that script and ask the other party also to submit the script. And when it is compared, the notations are compared, then it is easier to find it out than hearing it.
Fair enough. Okay, thank you for that. Thank you.
Absolutely welcome, sir.
And thank you so much. A round of applause, please. The first fireside chat for the day done. Thank you so much, Anil Lale and Lohita Sujit. It was a pleasure to hear from you and also have wonderful interactions taking place. Thanks to Dalip sir, who asked a question that's very, very relevant